Hello. Check. Check. Check.
Hello? Hello?
Everybody please rise. You may all take your seats. A warm good afternoon to one and all present here. On behalf of Rashtrasan Tukroji Maharaj, Nagpur University's Dr. Baba Saheb Ambedkar College of Law, I, Sia Chaudhary, along with my co-host Disha Sable, warmly welcomed you to the grand finale of 22nd Justa Causa National Moot Court Competition 2025. As we gather here, we are reminded with the words, "The law is reason, free from passion." In this room, reason will guide our arguments and passion will fuel our pursuit of justice.
Moot courts serve as the crucible where the future custodians of law refine their skills and test their mettle. We are honored to have such extraordinary talent and wisdom gathered under one roof today. Today's event is a testament to the small but significant steps that aspiring advocates take towards shaping a more just society. A very warm welcome to our esteemed judges, participants, and everyone joining us today.
To begin this significant occasion, we shall invoke the blessings of the Almighty. May I kindly request our dignitaries to come forward for the lamp lighting ceremony, a tradition symbolizing wisdom and enlightenment. Thank you, everyone.
Moving forward, to welcome our all esteemed guests and participants, audiences, may I invite Mrs. Vidya Naik ma'am to deliver the welcome address.
Good afternoon, honorable judges of Bombay High Court, Nagpur Bench, Justice Shri G. A. Sanab sir, Justice Shri M. W. Chandwani sir, respected Principal Shri Ravi Shankar Moore sir, our esteemed guest for today, Shri Ajay Chauhan sir, guest of the days, respected Pravina Khobragade madam, respected Adhara Deshpande madam, faculty members, and dear students. Good afternoon to everyone. On behalf of Rashtra Santa Tukroji Maharaj, Nagpur University's Dr. Babasaheb Ambedkar College of Law, it is my immense honor to welcome you all to the 22nd Justa Causa's National Moot Court Competition 2025. This prestigious event, which is being conducted in the centenary year of the year, has been a platform for showcasing legal brilliance, intellectual acumen, and the art of advocacy. We are privileged to have with us today the distinguished panel of judges of Bombay High Court Nagpur Bench, who with their vast legal knowledge and experience will undoubtedly elevate the proceedings and inspire us all. I extend a warm welcome to the judges. We are grateful to you for your constant support and for taking the time to join us today. To our participating teams, you have demonstrated remarkable skill, dedication, and resilience throughout this competition. As you present your arguments today, I encourage you all to seize the opportunity to engage with legal principles at the highest level. We look forward to witness the intellectually and thought-provoking the final round of the National Moot Court competition. I wish the teams the very best of luck. Thank you all.
Thank you so much, ma'am, for your warm words.
Moving forward, our esteemed panel of judges includes individuals of extraordinary legal acumen and experience who have contributed to the field of law. Celebrating our traditions of honoring esteemed guests, we now proceed to a moment of special recognition. It is an honor to introduce our first judge from the panel, Honorable Shri Justice Govind Sanab sir. Born in a farmer's family in Washim, Maharashtra, his lordship pursued his education with excellence, completing his LLB in first class from Sitabai Arts and Law College, Akola. Enrolled as an advocate, his lordship has practiced civil and criminal law before beginning his judicial career as a judge of the Small Causes Court, Bombay. His lordship has held several prestigious positions, including presiding officer of the Special TADA Court, where he delivered the landmark judgment of the 1993 Mumbai serial bomb blast case, and conducted proceedings in the 2611 Mumbai terror attack case. Elevated as an additional judge of the Bombay High Court, sir continues to serve with distinction. It is an honor to have you today, sir. I request Dr. Ravi Shankar Moore, sir, to felicitate Honorable Shri Justice Sanab, sir, judge at Bombay High Court, with tokens of gratitude and appreciation. Thank you so much, sir.
It is time to introduce our next judge from the panel, Honorable Shri Justice M.W. Chandwani sir, an esteemed member of the judiciary, was born in Gondia. Beginning his legal career in 1996, his lordship specialized in criminal, civil and taxation matters before being appointed as a direct district judge. Over the years, his lordship has served with distinction as district judge in Mumbai, Nagpur and Pune, as well as CBI judge handling several high-profile cases. His lordship has held prestigious positions including Principal District Judge Buldhana, Registrar at the Bombay High Court, Principal Judge of the City Civil Code Mumbai, and Registrar General of the Bombay High Court. His lordship elevation as an additional judge of the Bombay High Court reflects his exemplary service and commitment to justice. It is an honor to have you here today, sir. We now request Shri Ajay Chauhan sir to felicitate Honorable Shri Justice M.W. Chandwani sir, Judge at Bombay High Court, with a token of appreciation.
I now request our Principal, Dr. Ravi Shankar Moot sir, to felicitate Shri Ajay Chauhan sir, Member Management Council, Rashtrasan Tukroji Maharaj, Nagpur University, with a token of appreciation. Thank you, sir. Now, the moment we have all been waiting for, the final round of the National Moot Court Competition 2025 is here. We request the participating teams to approach the dais and commence the proceedings. We wish all the participants all the very best.
मोटर 1, मोटर 2 आणि मोटर 1, मोटर 2 एक स्पेसिफिकेशन
If your lordships permit, may I please state the facts of the case? Much obliged. Your lordships, the facts at hand can be divided into two things. First, what is VCW and what is VCW and B. Are your lordships with me? Much obliged. VCW is a local business established 100 years ago, and it has expanded in the state of MP also. It has been also adopted as a company under Companies Act 1956, and the domain name that is now in dispute in this case has also been used by VCW for a very long time. VCW is a tea vendor who works in the court precincts. So it has a very distinct business model. While considering that, VCW and B is a business located in a foreign country. That business has expanded. However, doing that, Makex is a parent company which took over the VCW hedge fund capital company, and then also took over BBT, that is Burger Baron Taser, which was VCW and B initially was Burger Baron Taser. However, there was a cryptocurrency scandal happened that in the state of America, because of which they suffered a big loss and they had to adopt a name VCW and B to change their identity and boom their business. While doing that, they also entered in the market of India, and in the market of India when they entered, they needed a domain name. However, when they checked up online, www.vcw.in, that is right now in the dispute, was already taken up by our petitioner, that is Vakil Chaiwala. When they came to know that, they went ahead and took over two different domain names, that is www.vcw.com and www.vcw.co.in to start with their business. After doing that, after a time in the year 2021, they filed complaint under NIXI. NIXI is a body which governs the domain name disputes as well as renders domain name. They filed a complaint under NIXI stating that their domain name, the domain name that is in dispute is taken by cyber squatting. Cyber squatting is illegal according to the trademark as well as Indian the provisions that govern .in domain name, that is INDRP provisions and INDRP rules of rules of procedure. While stating that they alleged VCW, authentic domain name, we can say prior use domain name, they accuse them of using domain name in bad faith as well as using it as a cyber squatting. Now we have a dispute over this domain name, exactly who holds the domain name in a legitimate course of event, as well as who is there any involvement of bad faith, and the arbitration proceeding that has went ahead. As I mentioned earlier, the VCW and B already had filed a complaint, and there is INDRP provision that after filing complaint, it goes for an arbitration. Arbitrator has passed an interim order stating that VCW.in will be injuncted. That will be terminated for time being till the final award is passed. And this is the entire case till now, that some of the points of arbitration as well as the further appeals and writ petitions that Vakil Chaiwala filed in the various jurisdictions of Indian territory are now in the dispute. VCW and B approached Supreme Court, and Supreme Court has ordered to club few matters, and those matters will be adjudicated by the Bombay High Court, Nagpur bench. These are the facts at hand. If your lordships are satisfied, may I move ahead with the statement of issues? Much obliged. Your lordship, statement of issues, if you may come to the page number 10 of our memorial. Memorial for the petitioners. Your lordship's memorial for the petitioners, the blue one. The statement of issues are arising out of arbitration first, whether non-granting of personal hearing is permissible. Are your lordships with me? The second issue is whether NIXI could have appointed the arbitrator in the view of statutory scheme of Arbitration and Conciliation Act and requirement of a formal agreement. Page number 10, Your Lordships, of the petitioner's memorial. So these are the issues that we are adjudicating upon. First one is arising out of arbitration, and there are 3 sub-issues. First, whether non-granting of personal hearing is permissible, whether NIXI could have appointed the arbitrator in the view of statutory scheme of Arbitration and Conciliation Act and requirement of a formal agreement, and whether the impugned interim order is maintainable. Second and third issues are as following: whether use of trademark by VCW is proper as per the scope of Trademark Act under section 134, arguments before High Court in writ under Article 226, and commercial appeal under section 13. Your Lordships, if you are satisfied, may I move ahead with the contentions in the matter? Much obliged. Your Lordships, I will be dealing with the issue number 1 and all the sub-issues thereunder, and the co-counsel will be dealing with the issue number 2nd and 3rd. Your Lordship, the first issue at hand, the very first issue is the grant of personal hearing. If your Lordships may come to the Moot memorial, para number 8. In the para number 8, if your Lordships may focus on the fact that personal hearing, the 4th line from the bottom. By way of an interim application, a personal hearing was specially called for by our petitioner, in the case Vakil Chaiwala. Mr. Cranberry, who is arbitrator in the case, denied the same, stating INDRP and INDRP rules of procedure. However, your Lordships, if you may come to the INDRP rules of procedure, your Lordships are provided with the INDRP rules of procedures. Therein, Rule 16 is in the dispute, your Lordships. In-person hearings. So, your Lordship, there is mentioned that there shall be no in-person hearing, including hearing by teleconference, video conference and web conference, unless arbitrator agrees on request of either or both parties that such hearing is necessary for deciding the complaint. In event a personal hearing takes place, the same shall be subject to maximum 2 hearings. Here it is clearly mentioned that even though personal hearings are exceptional matter and they are adjudicated under the discretionary power of the arbitrator, however, if the matter at hand is complex and it requires or it calls for a personal hearing to adjudicate upon and for a clear understanding of the matter, there is a requirement of personal hearing. Your Lordship, our petitioner was earlier given the chance for written submission. We don't argue on that point. However, now I would like to establish why our matter was complex to understand and there was a dire need of in-person hearing which arbitrator denied us, and there was a procedural lapse and violation of clear-cut violation of principles of natural justice. What is principle of natural justice says? It says that audi ultum partem, both the parties must be given the equal chance. While giving the equal chance, when the party petitioner here, VCW, asked for impersonal hearing to clear the matter, arbitrator denied without even considering that there is a complex factual matter, and that led to impugned interim order, which I will explain in the subsection T, that how that order is passed without application of mind. Your Lordships, if you may come to the moot problem. Vakil Chaiwala is a business that is established 100 years ago. The trademark is acquired in 1983 only, and it has been renewed over the period of time also, every now and then. While doing so, IN.in domain name has also been used by VCW, that is a petitioner, for a very long time, even before the learned respondent VCW&B entered the market of India. This states the principle of prior use, and principle of prior use has been held in various cases which I will be dealing forward, and I will provide you the copies of such precedents also. Your Lordship, we must understand that who was holding the domain name first. The VCW is clearly holding that domain name earlier, much earlier than VCW entered the market. When we consider the principle of prior use, we must understand the case of Travancore. Travancore Ryans. If your Lordships may come to the page number 2, in the head note, held part, keyword the court has held. For the convenience of your Lordships, I have highlighted the part. There is clear mention that where complex and difficult questions requiring familiarity with technical problems, as in the present case, are raised, it would conduce better administration and satisfactory disposal of the grievances of citizens if personal hearing is given. As I am stating, there was a principle of personal prior use. Principle of prior use is established in the Tata Motors case that was adjudicated under INDRP provisions only by arbitrator. I will just give you the facts of the case. If your Lordship ever have heard the Harrier automobile that Tata launched, Harrier is the car that Tata Motor launched. Harrier was a name that the respondent in this case was using much earlier than Tata Motors. When the arbitrator got notice of this, arbitrator passed this order. For the convenience of your Lordships, I have marked the order. If your Lordships may come to the decision of the court, which is on the page number 14. This discussions and finding what arbitrator exactly has found. On the 15, I have highlighted in the very bottom paragraph that in the foregoing discussion, complainant has failed to satisfy this tribunal, the respondent does not have prior proprietary right. So, Tata Motor failed to prove that respondent was not using the domain name prior to Tata Motor. This entire case is based on the principle of prior use. In this case, arbitrator allowed respondent to go ahead and use the .in domain because it was using much earlier than Tata Motor. So Tata Motor had no legitimate right to go and file a complaint to cancel or transfer the domain name. So this very case clearly establishes the principle of prior use, which is our very basic contention that our domain name was acquired much earlier than VCW&B, and when VCW&B was not even in the market of India. When we contend that if personal hearing would have been provided, we would have been able to pursue the arbitrator and tell that our case is on the basis of principle of prior use. The arbitrator did not provide us a chance to orally argue what our contentions are. Written submissions were insufficient, they did not convince the arbitrator, and that led to a procedural lapse and violation, clear-cut violation of natural justice, principle of natural justice. If arbitrator would have taken the small note of complex matter and given a chance to in-person hearing, he would have understood that there was no need to pass an interim order stating that the domain name shall be terminated till the final order is passed. We are now getting injured because of this interim order, that we are unable to use that domain name whatsoever, and our entire backend server is run on that domain name. Yes, Your Lordship. Yes, Your Lordship. Yes. Yes, Your Lordship. Yes, Your Lordship.
Now, it is not that you are the respondent in the matter which decided behind your back. Number one. You are the petitioner before the court.
VCW is a petitioner. What happened is earlier when the arbitration proceeding was initiated, that time VCW and B was petitioner, rather complainant we may say, and then the further writ petitions and commercial suits were filed by VCW. VCW and B. Yes.
Now, in view of this last 16,
Yes, Your Lordship.
how can you explain this? How can you explain this? How can you make a grievance?
Your Lordship, there is a discretionary power that is given to arbitrator, that he may give in-person hearing if there are complex matters. What? Yes, Your Lordship. No hearings shall be held.
After completion of the proceedings, you made a request to the arbitrator to grant a personal hearing and
Your Lordship, when I pointed that out in the Moot proposition, that interim application was filed by VCW. When the return submissions were filed by VCW, we also went ahead and filed an interim application stating we need in-person hearing. However, arbitrator clearly denied that, stating INDRP and INDRP provisions, which was an insufficient reasoning. Your Lordship, there also is a procedural lapse. However, I am coming one by one on the point that there was clear principle of prior use. We were the holders initially, way before the VCW and B entered the market. Second is, as I mentioned, arbitrator has failed to mention the reason, exact reason why he denied in-person hearing. When it comes to administrative authority adjudicating upon any case or a quasi-judicial body, they must provide a reasoned judgment while passing an order. However, by just merely stating that under INDRP and INDRP procedures, we are denying the right of in-person hearing, he has not taken into consideration the complex matter. We are stating we have a prior use. If we have a prior use, that lead to no bad faith. Your Lordship, bad faith will involve if we are trying to sell that domain name. We have absolutely no intention to sell that domain, and that is highlighted from the fact that we are running entire back-end service. We have currently more than 8,000 employees. Currently, it is expanded out of Maharashtra in the state of MP also. While in this scenario, if we are running such a big back-end service on our domain name, we have absolutely no intention to sell it off to a third party. That
you relied on the case of Travancore Ryan Limited.
Yes, Your Lordship. Complex factual matters are involved.
Requiring familiarity with the technical problems.
Yes, Your
How
Lordship.
you will find your case fit in these words, because your claim is that prior use here.
Yes, Your
Whether in
Lordship.
that case it will be complex, difficult question requiring formality with the technical problem.
Your Lordship, if the written submission would have been sufficient, the learned arbitrator won't have passed an order stating the termination of dot-in domain. That clearly states that arbitrator did not really understand the factual matrix of the case. If he would have considered the factual matrix only based on the written submission, he would have simply understood that our case was a principle of prior use. There was no involvement of bad faith. We had a legitimate interest. What legitimate interest is? That we were using for a legitimate business purpose. We were running our entire back-end service. There were no illegal activity that was getting held on the under the domain name. This all clearly states. Arbitrator.
Whether that case will become complicated or complex, you can say that in appeal that yes, no non-application of mind by the learned arbitrator. But can you say that just because he did not apply mind, personal hearing of is necessary, which is district
Why I stated that is because if you will observe all the cyber squatting cases, most of the cyber squatting cases get disposed of in the favor of complainant, stating that complainant has right over the domain name more than the respondent. A lot of times complainant gets the favor than the respondent. However, in this very case is very much special. What is happening is the VCW&B is not even an Indian company. It is some foreign company which has entered in India. If there are too many, a lot of things are involved, not just prior use, but which company is asking for, exactly who holds the trademark, who has a trade, is there any trademark infringement? We have to adjudicate upon a lot of questions. Is there involvement of bad faith? Are the parties holding legitimate interest? We must understand the fact that both the parties hold a registered trademark. In that case, who exactly holds the legitimate interest for domain name? That is also essential part to adjudicate upon. Not just one, but 10, there is a list of 10 things that an arbitrator was supposed to delve into, which he has clearly overlooked. If he would have given in-person hearings, it would have been easier for us to state that. What are the grounds that arbitrator has missed to adjudicate upon? This is the reason why we are stating that the non-grant of personal hearing was in the clear violation of natural justice, and that has led to not applying mind while passing the interim order. This is the only reason why we are stating that the matrix of the case are very much complex and we should have been given right to in-person hearing. Are your lordships satisfied with the first issue? May I move forward with the second? Much obliged. Your lordship's second issue at hand is appointment of arbitrator by NIXI. This is very interesting. Your lordship, when we file a case under NIXI, NIXI is the authority who goes for arbitration proceeding as well as select the arbitrator. While in the Arbitration and Conciliation Act, your lordships may consider the section 11 of Arbitration and Conciliation Act, which talks about the appointment of arbitrator. And appointment of arbitrator is appointed through parties' consentment. So entire Arbitration and Conciliation Act is based on the fact of party autonomy. Whether I want to go for arbitration, whether I want this as my arbitrator, party comes to a consensus. If party are not able to come to a consensus, then the judiciary will adjudicate upon. Party can approach judiciary and then go for an arbitration proceeding. But there is clear violation of this. Party has given absolutely no chance to understand whom to choose as an arbitrator. NIXI has unilaterally chosen arbitrator on the behalf of petitioner or in this case petitioner, and clearly violated the principle of party autonomy, which is the crux of entire Arbitration and Conciliation Act, which is in the section 7, that is the agreement, what is arbitration agreement, and section 11, appointment of arbitrator. Both the sections states that there must be party autonomy and there must be consents between parties. The parties should come to the consensus whom shall they consider as arbitrator. And they must understand whether they really want to go for arbitration proceeding. That is the reason why here is clear violation of arbitration as a clearly violation of NIXI, that they have unilaterally selected the arbitrator and not even asked the respondent in the arbitration case, and here petitioner VCW, that whether they really want to go for arbitration proceeding. That is the reason why it is clearly in violation of the Arbitration and Conciliation Act, from which the INDRP takes inspiration. Exactly contrary to each other, your lordships. Your lordships may come to the what are rules of INDRP or arbitration. Yes, I will come to that point also, your lordship. I understand. Yes, Your Lordship. So INDRP and INDRP rules of procedures are the ones which govern the entire domain dispute resolution. And NIXI is a body who has authority to invoke .in domains. However, it is very much interesting that NIXI is a non-profit organization established under Section 8 of Companies Act, which is not really invoking its power from any statutory act. NIXI is not a body. This is a policy framework. This is not a statutory legislation. When it comes to statutory arbitration, there is a need of statutory legislation, Your Lordship. Yes, Nixie, yes. Yes, Your Lordship.
What is that rule which provides the procedure for appointment of arbitrator, compulsory appointment of arbitrability of the dispute in this situation?
Yes, yes, yes.
There was no need to go before fixing.
Yeah, I got it, Your Lordship.
The procedure provides, or rather you may say, the statutory arbitration. Then in that event,
Yes, Your Lordship.
justify or buttress your submission by taking the assistance of section 11 of the arbitration.
If Your Lordships may come to the .in dispute nominated policy. Yes, Your Lordship.
But we have to see the powers of fixing.
Yes, yes, indeed.
So there are the two issues. The right with fixing to entertain an application for appointment of an arbitrator. And second, the appointment of an arbitrator. Whether the rules provide that before appointment of an arbitrator in this situation, the NIXI is supposed to take the consent of the applicant. This is the issue.
Your Lordship, our co-counsel in the second issue will deal with the writ petition that VCW has filed before the High Court stating the virus of the INDRP and INDRP provisions. Why they are also violating our rights, the principle of natural justice. What I am trying to state here is
That there is a provision. Otherwise, there would be no need to challenge the virus.
yes, I would come
So
to
there
that
is
provision.
an inbuilt mechanism which provides for
Arbitrator.
appointment of an arbitrator and powers of the NIXI to appoint the arbitrator.
Arbitrator.
So if you say and submit that it is contrary to the principles of law, natural justice, or violative of other principles of law, including section 11, then you are right. But what we are asking you, what is that
Principle.
procedure?
Oh.
What is that procedure which is prescribed under these rules?
Yes, Your Lordship. If Your Lordships may come to the policy, clause 5 of the policy, there is dispute resolution process that is given. Clause 5 states that, if Your Lordships may come to the policy, not the rules and procedure, policy. My researcher will provide the copy of it. That is rules of procedure. This is policy. Your Lordship, I am talking about policy, Your Lordship. There are policy, and then about that policy there is rules of procedure. Two different things are there. If Your Lordships may come to the clause 5 of the policy, dispute resolution process. That entire clause clearly mentions that the .in registry shall appoint an arbitrator from the list of impellent arbitrators. That means they are unilaterally appointing. Maintained by the registry, the list of arbitrators shall be published online by the .in registry. It was of no use if I don't have any autonomy to choose my arbitrator, then only displaying that on the website of no use. Its website www.registry.in. The arbitrator shall conduct the arbitration proceeding in accordance with the Arbitration Conciliation Act. If arbitrator is supposed to conduct the entire arbitration proceeding in accordance with the Arbitration and Conciliation Act, then he must have understood the section 7 and 11. Section 7 and 11 gives party autonomy. It talks about the concerns between the parties. If you are taking inspiration from some act, if you are stating that this act is taking inspiration or is working in accordance with the ANC Act, then why the NIXI has a power to unilaterally appoint the arbitrator? And when your lordships, if your lordships.
Your sum and substance of the argument on this point is that there is statutory provisions under section 11 and then vis-a-vis policy. So according to you, the provisions will prevail and policy will, that is your sum and substance?
Yes, your lordship. And when your lordship targeted on the pointed out the statutory legislation, why that will not prevail is because the INDRP is a policy framework. It is not a statutory legislation. When a statutory arbitration is conducted, like Electricity Act or Housing Society Act, there is a proper statutory legislation that gives power for a statutory arbitration and unilateral power to invoke arbitration proceeding. There is a mere policy framework which is even brought by some non-profit organization established under Section 8 of Companies Act. That is the reason why it entirely erases of the point of statutory arbitration as well. This is the reason why we are challenging the INDRP and INDRP proceedings also in the writ petition. And this has cleared out the point that there was no maintainability when NIXI went ahead and unilaterally appointed the arbitrator. This is how I summarize the issue, sub-issue 2 of the problem. If your lordships are satisfied, may I move forward with the sub-issue 3? Sub-issue 3 at hand is very interesting. It is interim order that is passed by the arbitrator. If your lordships may come to the para number 8, therein your lordships will notice how the arbitrator has passed an order. Moot proposition, yes. It is clearly mentioned that Mr. Cranberry was appointed as an arbitrator. A detailed response was filed by VCW, and by way of interim application, personal hearing was challenged, which we saw so far. Here, by way of interim order, Mr. Cranberry shut down the website till further decision by issuing directions to NIXI. It is very interesting, your lordship, that an arbitrator has no authority to invoke interim order, which is like a final relief. Your lordship, by passing interim order, it has terminated VCW from using the dotting nomen entirely till the final relief is granted. This is exactly the phase of final relief. Final and interim orders cannot be final relief. For that, I will provide a precedent. If your lordships may come, my researcher will provide the Devraj case. Yes, your lordship. Yes, your lordship, I am coming to that point. The very case is talking about that. If your lordships can come to the highlighted part of Devraj versus State of Maharashtra, that very case talked about the two grounds on which the interim order can be passed. And what should be the interim order? Should it be the final relief, or should it be can it have a phase of final relief, or it should not be like a final relief? While considering that, if your lordships may permit, I will read the paragraph for your convenience. Yes, your lordship. So, we must understand what is the prima facie case. Is there injury to the party? And we must consider the balance of convenience. Your lordship, these are the points that Devraj case has stated. Balance of convenience, is there a damage suffered by parties? And if the interim order, like a final relief, not passed, is there any problem that a party will suffer? If a party is suffering some issues, then a court or an arbitrator has power to issue an interim order like a final relief. However, I would love to take your attention on a Paragraph 7 of the Moot proposition. Is your lordship with me? Very last line of the same paragraph, your lordship. That is, in favor, in the meantime, they went ahead, they as in VCW and B. They went ahead and have commenced business operation by obtaining domain name vcw.com and vcw.co.in. Your lordship, this must be considered that the VCW and B is granted a final relief through interim order, but VCWB has an option to run their business from 2 different domains already with them. They are not suffering any injury if the interim order is not passed. Whereas our petitioner entirely runs its backend servers on the only one domain. If this backend server is terminated, we have no option left with us. Our entire system will collapse. How we are going to handle 8,000 employees? And your lordship, Arbitration and Conciliation Act talks about preservation of status quo. The status quo has to be maintained, that when a pet dispute is going on, a interim order cannot be passed which has a face of final relief, because arbitrator is supposed to maintain the status quo. Arbitrator is clearly not maintaining the status quo. It is terminating our domain name and infringing a right to use that very domain even before the final relief is granted. We don't know final relief is granted in whose favor. Till then, we had a right, we have a legitimate right to work on that domain name because we have no other option. We can see in the Moot proposition that VCW and B has a much earlier already opted for 2 different domains when they entered in the business of India. It is not, so domain name, there were domain names they were holding in the foreign country. But when they came to India, they noticed .in domain name is already taken. They went ahead and registered with 2 different .in domains. What that means is they are not really having any damages. No injury has been caused. What is the contention? There is no balance of convenience, your lordship. When this Devraj case talked about balance of convenience, they talked about this only, that there must not be inconvenience caused to only one party. Arbitrator cannot be biased. If they have option, if they can run their business, business is not getting shut down because they don't have in domain name. However, if we don't have .in domain name, our entire backend service will collapse. If your lordship may permit, may I? Much obliged. This clearly states that your lordship, again, arbitrator, without applying mind, has given interim order a face of final relief when it was not even needed. There was no balance of convenience, no injury was caused to the respondent in the case when they had already option to go ahead with their business, and it has caused irreparable injury to our petitioners that they cannot use their domain name even having legitimate use, no bad faith, no cyber squatting whatsoever. This is the reason why we have challenged this impugned interim order, which is passed by arbitrator without applying mind and which is in clear violation of principles of natural justice as well as balance of convenience and the precedent that is stated in the Devraj case that a final relief can have a face of an interim order. Interim order can have a face of a final relief only if there is damage caused or a balance of convenience, which is clearly not in the case. That is the reason why we contend that the interim order must be quashed. If your lordships are satisfied with the contentions, may I give the podium to the co-counsel for the further
Not satisfied with the manner of the request.
If your lordship,
It must be passed. You are making the request.
if your yeah, if it may quashed by the honorable judge.
Yes.
Apologies, your lordship. Much obliged.
The position which may apply
Yes.
The permission of the bench may I start the
Just for the information, as you all are aware, 45 minutes is for each team and not for a single movement.
Your Lordship, I am the counsel number 2 from the side of the petitioners, and I will be dealing with second issue and third issue. Second issue being whether use of trademark by BCW is proper as per the Trademark Act under section 134. Your Lordship, to understand. Am I audible? Much obliged, Your Lordship. With the permission, may I start? Your Lordship, while I'll be dealing with the trademarks issue, I would like to bring attention of the Honorable Bench to the Trademarks Act. Firstly, to the immediate definition of what is trademark as per the section 2ZB of the Trademarks Act. Your Lordship, it has to be noted by the Honorable Bench that there is a clear wording where it has been said that capable of distinguishing the goods or services. Out over here, what does that mean? That trademark has to be distinguished. It has to have a distinctiveness in itself. Then only it can be said as a trademark. Now, I would also like the Honorable Bench to bring attention to section 2, subsection 1M of the Trademarks Act, wherein the word mark has been defined, wherein it has been stated that it includes name, word or letter. Out over here, we have a mark with a name, that is Vakil Chai Wala. We have a mark with a logo, that is the composite mark of the Vakil Chai Wala, and we also have an acronym mark, that is VCW. Out over here, now I like to bring attention of the Honorable Bench to section 210 of the Trademarks Act, which includes the abbreviation of the name trademark. Abbreviation of the name trademark, which means that VCW, which is an abbreviation of my own trademark, it can also be registered. And lastly, all these trademarks, the mark, the trademark itself, the name trademark, the composite mark, and the individual mark of an acronym, all have been registered by the learned by the petitioners. So it can be stated that since all the trademarks have been registered, we have a genuine reasoning of owning these trademarks, and the registry, the trademark registry, is very much well enough to understand what should be registered and what should not be registered. With regards to that, Your Lordship, moving forward, I'd like to bring attention of the Honorable Bench to a case of Rajat Agrawal and Spartan Online. My researcher will be passing off the judgment for the convenience of the bench. Your Lordship, on the page number 15, I have marked the full submissions, but with regards to the restrictions of my time, for the convenience of bench as well, I'll just summarize it in 2 words. That the judges in that court stated that there are 2 things which are important when a trademark has to be considered. The 2 wordings were business branding and consumer navigation. If a trademark is of such nature that it has a business branding as well and also focuses upon consumer navigations. Out over here, Your Lordship, if the Lordships may draw attention to the Moot proposition, paragraph 1. to the Moot proposition paragraph 1. For the convenience of the bench, I will read the statement. The business model of VCW revolves around opening an outlet either in court precedents or in immediate vicinity and targeting the crowd of litigants and lawyers coming to the court. Out over here, there's a new model which is taken into consideration. If the new model is of such nature, that has a unique business branding altogether. Now, this type of trademark is nowhere registered. So this is something new which is brought by the petitioners, and that's the reason we have a correct reasoning of holding that trademark under business branding. Now the second condition, which was with regards to consumer navigation. Now, for consumer navigation, we need to have a unique trademark name. Out over here, a unique trademark name has been brought by the Vakil Chaiwala, because if we focus upon the name Vakil Chaiwala, which means that there's a lawyer who is entering upon the business of tea. So this is something which is a new concept altogether, wherein we have brought a concept of a lawyer who is engaging into the business of tea. So this becomes, with your lordship's permission, may I continue? May I be granted some more time? Obliged. Your lordship, now there's a new consumer. Your lordship, I have to conduce the issue number 2 as well issue number 3. May I grant some more time?
How much we can, as per your rules?
As per the rules of the OC committee.
15 minutes.
Oblige your lordship. Oblige your lordship. Your lordship, with regards to consumer navigation, out over here, what is important that we have brought something new concept. That's the reason it's a consumer navigation. It has become a secondary name of ours. Vakil is a primary name, but Vakil Chaiwala has become a secondary name altogether. Now, with regards to that, this was with regards to how I have registered my trademark. Now I'll focus upon the point that how VCW, even after the opposite party's trademark has already been registered, how our trademark will sustain more than theirs. Out over here, there are two conditions wherein a trademark can be settled off. One being cyber squatting and another being passing off. Cyber squatting, as my co-counsel did, it has not happened out over here. With regards to passing off, section 27 of the trademark that deals with passing off. There was a case of Yahoo versus Akash Arora, wherein it was stated that my co-counsel will be passing off the case. In that case, your lordship, 3 conditions were taken into consideration while dealing that how trademark will sustain even after the other party has already trademarked something. That is with regards to 1, goodwill, 2nd, misrepresentation, 3rd being damage. If I have a goodwill, if the other party has a goodwill, if the other party has goodwill, then they have the right to claim the trademark. They have a goodwill, they have very good goodwill, they are international market branders, they have a very good goodwill. But second condition being misrepresentation. The opposite party against whom the complaint has been filed, they should be misrepresenting the opposite party's trademark. We have no chance of misrepresenting the trademark because we are having it in prior. We are using the trademarks, using the name itself since 100 years ago, and I have trademarked the same since 1983. How can I misrepresent their thing? And now the second thing, that is with regards to damage. If I have not misrepresented, there is no chance that I have damaged something of theirs. I have not damaged, and more importantly, my server is the backend server. Even if any random person wants to access my server, they need my permission to access that server. So they cannot have a single damage because of the same. Now, with regards to that, this was with regards to my submission on the second issue number 2. With the permission of the bench, may I move to the issue number 3? Yes. Much obliged, Your Lordships. Your Lordships, while dealing with the issue number 3, which is with regards to arguments before the High Courts under Article 226 of the Constitution of India and commercial appeal under Section 13 of the Commercial Courts Act. There are 2 sub-issues in the present case, that is with regards to the writ petition, and second is with regards to the commercial appeal. The council will be dealing with in 2 different stages, one being the writ petition. Your Lordship, out over here, the writ petition have been filed by the petitioners with regards to that certain policies, certain rules and certain norms of the INDRB and INDRB rules of procedure are not as per the normative views of the law, which is they are against the principles of natural justice. Now, how? If your Lordship draw attention to clause number 16, as my co-counsel stated with regards to in-person hearings, when we read the same with clause 4A of the same, the INDRP rules of procedure, which states that only 5,000 words shall be granted to both the parties to bring upon their written submissions to the arbitrator. When it's a normal fact that when a person wants to complain, they'll be registering a complaint. But when a company, when an individual has to defend that case, they need more submissions to present all the facts of the case, the intricacies of the case, and all the laws to be argued upon. So number of words are not limited, and that's the reason there is a need to bring a change in the INDRP rules and rules of INDRP and INDRP rules of procedure. With regards to the commercial appeal, because of time constraint, if the Lordships are much obliged. The Lordship, with regards to commercial appeal, I'll bring attention of the Honorable Tribunal that this is a case where we have a backend server, but they have two servers. Our party has just one server, they have a problem with the same, but they are owning two servers, which we don't have a problem. They can coexist with us, but they have a problem because they want to not conduce into competition law. They want some other party who may, on certain occasions, become a big company. They don't want the same because it's in the same food compositions. They want us to sustain off our domain name. Now, with regards to this is a case of reverse domain name hijacking, which means that since they have a lack of right, since there's a bad faith with them, since there's a baseless nature of having that domain name, they are actually doing a reverse domain name hijacking. And with regards to that, there was a case of Tata Motors Limited versus Amit Badiani, wherein it was stated that if the trademark is in prior use and has a legitimate value, there is no need to take that trademark from the holder of the same. And since we have a prior use, I request the Honorable Court to adjudicate upon the same and pass a favor on the part of the, if the Lordship want to hear the prayers, or much obliged, Your Lordships. The petitioner stands of the oral submissions. Much obliged.
Yes, you can proceed. Yeah, please.
Three, two, one. Good afternoon to the Honorable Bench. If it may please, the Council seeks permission to address Bench as your Lordship. Much obliged, your Lordship. The Council is appearing before the Honorable High Court in the matter of Vakil Chaiwala, petitioner, versus VCW and B, respondent, on behalf of the respondent. The Council will be dealing with the first issue, while the co-counsel will be dealing with the second and third issue. The counsel for respondent initially approached the Honorable Supreme Court under Article 136, read with Article 142 of the Constitution of India. Subsequently, the Honorable Supreme Court has clubbed all the matters together before the Nagpur bench of the Bombay High Court. Hence, we are before this Honorable High Court as directed by the Supreme Court. The counsel seeks permission to begin with the statement of facts. Vakil Chaiwala is a family-owned business established in 1906 which sells tea, coffee and snacks near courts. On the other hand, VCW and B, originally a hedge fund launched in 1998, later acquired by MCX, which is the parent company of the respondent, a fast food brand, and it rebranded itself in 2006 after a cryptocurrency scandal involving Bit token. The council would like to mention that the name of the VCW and B before was Burger, Barer and Czar, which in its initials, if we are speaking acronym, it's BBT. But due to the cryptocurrency scandal in 2014, the parent company was forced to change the name from BBT to Very Crispy Wings and Burgers. Yes. The VCW&B entered India in 2019 under the Invest in India scheme, and also that the VCW&B has domain names such as www.vcw.gb and www.vcw.eu already, and it has 750 outlets in Great Britain and European Union. The dispute arose when VCW&B sought ownership of the domain name www.vcw.in used by Vakil Chaiwala for back-end operations by filing a complaint with the NEXI under the INDRP rules and rules of procedure, in which the arbitrator favored in favor of the VCW&B through an interim order. In response, VCW initiated litigation onslaught, which include a trademark suit under Section 134 of the Trademark Act 1999 in the Nagpur Commercial Court, a writ petition in the Nagpur bench of the Bombay High Court challenging INDRP and its rules of procedure, an appeal in the High Court's Commercial Appellate Division bench against the interim arbitration order, a competition law complaint alleging abuse by VCW&B. Ultimately, VCW&B approached the Supreme Court under Article 136 and 142 to shield itself from this litigation onslaught. The Supreme Court consolidated matters, all the matters except those pending before the Trademark Registry and the Competition Commission of India, directing them to be heard at the Nagpur bench of the Honorable High Court. The Council seeks permission to move on to the issues of the case. Yes, Your Lordship. There are a total of 3 sub-issues arising out of the first issue, that is arising out of arbitration. First, whether non-granting of personal hearing is permissible. The Council humbly states before this honorable bench that the petition... Yes, Your Lordship. The trademark VCW was registered by the petitioner first, Your Lordship.
In which year?
In 1983. They have, yes, 19... in 2019, Your Lordship. In 2019, we have entered India, yes. So that time we have already registered, yes, Your Lordship. Yes, which, Your Lordship, can the Council continue? Yes. That the petitioner's claim stating that the request which was denied by the arbitrator and in turn violated the principles of natural justice has no fundamental basis here. Your Lordship, my researcher will give you the copy of the INDRP rules of procedure and the INDRP. Your Lordship, the Council would like to focus on Rule 16 of the INDRP Rules of Procedure. Yes. Which explicitly state that there are to be no in-person hearings unless upon the request of either or both parties deeming that such hearing is detrimental in deciding the complaint. This rule establishes that personal or in-person hearings are only granted in very exceptional cases and is a privilege to the party. And the scarcity of case laws regarding this further proves that this method works. The Council would like to state that the INDRP, which is the dot-end dispute resolution policy, is a dispute resolution mechanism which is derived from the Uniform Domain Resolution Policy, which is further under WIPO, which is the World Intellectual Property Organization, whose main aim is the protection of trademarks with global consistency, and that domain names are used in good faith. The entire rationale behind this process is to ensure that disputes are resolved swiftly and effectively. Yes. Your Lordship, the Council would like to state that here the petitioner failed to prove that the urgency needed for a personal hearing. The Council had asked for a personal hearing for the arbitrator, but here the Council would like to state that both the parties had given the chance to give their to file their replies. In this case, the formal complaint was given by the VCWNB, and a detailed reply here was given by the Vakil Chaiwala. Not a half-hearted reply, detailed reply stating why the domain name www.vcw.in should not be transferred to the VCWNB and should be kept instead with the vcw.in. After understanding all of these facts and circumstances, the arbitrator gave the interim order doing the shutdown of the website. So therefore, the principles of natural justice which the petitioner is arguing here is not applicable because the respondent was given the chance to give the detailed reply, which in this case they already have given, Your Lordship. Yes. Your Lordship, also that the natural justice here, that the as stated under Rule 16, the personal hearings are totally under the discretion of the arbitrator here, and so therefore that the principles of natural justice are not violated here. Secondly, that the non-grant of a personal hearing does not violate principles of natural justice. Both parties were afforded equal opportunity to submit written arguments and evidence, as both the parties have the 5,000 word limit. Not one of the parties, both parties have to follow the same rules and procedures. So here the natural justice, principles of natural justice is being followed, because the VCWNB also has to file the complaint within those 5,000 words, and so also has the petitioner. Yes. The Council would now like to move to the second sub-issue, Your Lordship.
Let us know what is your submission on the point that there is no statutory backing to the policy which restrict the personal hearing in some of the cases, or rather it is to be given in rarest of rare case.
Yes, Your Lordship.
So what is your submission of the to this point on the submission of petitioner that
which clearly states that they have the power to adjudicate all the disputes arising out of arbitration. And since it's a company under the Section 8, which is a company of a charitable trust, and it comes under the Ministry of Technology. So therefore, this is not a statutory rule, but under the Companies Act, the company has the power as stated in the company as stated in the Articles of Association Clause 8. Yes, Your Lordship. The council would now like to move to the second. Yes. The council humbly states before this High Court that NIXI's appointment of an arbitrator domain names is valid under the statutory scheme of the Arbitration and Conciliation Act. NIXI derives its authority under the INDRP from the Arbitration and Conciliation Act. The council would like to mention the clause 5 of the INDRP, which states the arbitration process, how the dispute is to be solved. The main thing the council would like to state here is that in the clause 5, as stated by the petitioner, that there is no transparency in the arbitration proceedings. Your Lordship, it is clearly stated in the clause 5 that the IND registry shall appoint an arbitrator from the list of empaneled arbitrators. So there is already a list of empaneled arbitrators already on the NIXI's website. So there is already a transparency here that who the arbitrator will be appointed from those lists. Yes, Your Lordship. And also this is to be read with the section 7 of the Arbitration and Conciliation Act 1996. Section 7 of the Arbitration and Conciliation Act defines an arbitration agreement as agreement by the parties to submit disputes to the arbitration, whether such agreement is in the form of a clause in a contract or a standalone agreement. It can also be implied through conduct or correspondence between the parties. This policy framework has been drafted in accordance with the Arbitration and Conciliation Act. It is given under Rule 13 of the INDRP Rules of Procedure, Your Lordship. If you will see that, in the INDRP Rules of Procedure, the general powers of the arbitrator, Your Lordship. An arbitrator shall conduct the arbitration proceedings in such a manner as it considers appropriate in accordance with the Arbitration and Conciliation Act 1996 amended as per the. So here the arbitrator is already following the rules and procedures which are needed under the Arbitration and Conciliation Act. Yes. Your Lordship, the council would like to state that the petitioner claims that there is no formal agreement between the parties. The council would like to focus on that now. By registering a domain name with the NIXI accredited registrar, the petitioner implicitly agrees to abide by the INDRP and its procedural rules. This implicit consent forms the arbitration under Section 7 of the Arbitration and Conciliation Act 1996. Here the respondent would like to focus on the Section 7 subclause section 7 2 subclause C, B, sorry Your Lordship, section 7 subsection 4 and subclause B, an exchange of letters, telex, telegrams or other means of telecommunication, including communication throughout electronic means which provides a record agreement. Your Lordship, the council here states that the domain name www.vc.in is registered by the petitioner with the NIXI. Here the domain names www.vcw.co.in and www.vcw.com are already registered by the respondent here. So this clearly implies that all the, as the council has stated before, so all the disputes arising out of the arbitration shall be adjudicated by the NIXI. And the petitioner has also agreed to this. Furthermore, the INDRP rules of procedure explicitly states that disputes arising out of domain registrations will be resolved through arbitrator conducted by NIXI. Yes, Your Lordship. The council would now like to move to the third sub-issue, Your Lordship. Yes. Yes. Your Lordship, the council would like to here state that the council was stating that there is a formal agreement between the petitioner and respondent. Yes, Your Lordship. Your Lordship, the Council would like to respectfully disagree because respectfully disagree because here, as and when the petitioner has registered the domain name, as they have stated that they have registered the domain name since a long time, so they are already a party to the agreement which are to be done by the arbitration of disputes, as stated in the NIXI. Yes, Your Lordship, because the NIXI, as stated by the Council, already has the power. By registering these domain names, the Council would like to state as if the same case would have happened. No, Your Lordship. It's a company under the company's Section 8 of the Companies Act, Your Lordship. Yes, as stated by the Council earlier. Yes. The Council would now like to move on to the third sub-issue of the first issue, whether the impugned interim order is maintainable. Your Lordship, under Section 17 of the Arbitration and Conciliation Act, it grants the arbitrator the authority to issue interim orders that are deemed necessary for the preserving the subject matter of dispute. In this case, the subject matter of dispute is the domain name, that is www.bcw.in. Yes. Your Lordship, the Council would like to state this interim award applies to be an this interim order applies to be an interim award. The Council would like to explain that further, with the permission of the Lordships. Yes. Yes, Your Lordship, as you will see, under clause 11 of the INDRP remedies, the remedy, though there are only two remedies available under the INDRP rules, INDRP and its rules of procedure. First, that is for the cancellation of a registrant's domain name or the transfers of the registrant's domain name. Yes. The Council would like to state that here the arbitrator has followed all the rules and regulations needed under the Arbitration and Conciliation Act, because first, he has given the interim award, which says he has cancelled the domain name, which amounts to an interim award. The interim award amounting to an final award is stated both in the Arbitration and Conciliation Act and also in the INDRP rules of procedure. Therefore, which makes it an interim award and not an interim order, Your Lordship. Yes. Yes. The Honorable Supreme Court of India has stated that once an arbitral tribunal is constituted and proceedings are pending before it, the court shall not continue to take up applications for interim relief. The Council would like to focus on the case of Arcelor Mittal Nippon Steel India Limited versus SR Bulk Terminal Limited on page number 21 of paragraphs 67 and 68, Your Lordship, where it is clearly where the court emphasized that the remedy provided under section 17 of the Arbitration and Conciliation Act should be utilized unless it is found to be ineffective. In this instance, the interim order regarding the domain name www.bcw.in, which involves shutting down of the website on a temporary basis, aligns with the scope of interim relief under the section 17 of the Arbitration and Conciliation Act. The clauses and rules laid in INDRP framework, coupled with the Arbitration and Conciliation Act 1996 and judicial precedents, support the applicability of the interim order in this manner. Your Lordship, the Council would like to state that the petitioner has mentioned the case of Tata Motors Limited versus Amit Badiani, where they have stated that, but here the Council would like to state the facts that the Harrier used to sell, in this case, Harrier used to sell toiletries instruments, and the Tata Motors used to sell cars. Here the class of goods are totally different, Your Lordship, as we can see. So therefore, this case cannot be implemented here, because here both the classes, both the companies come under the trademark class 43. Yes, and because in the hotels and restaurants, but here in this case, the classes of goods are not similar, so they can't be applied here. Yes, the Council will also yes. Your Lordship, now the co-counsel will continue with the pleadings of the case relating to the second and third issue of the issues respectively.
The Council would now deal with the issue number 2 and 3 at hand, and the Council would seek permission to continue with the second issue. Your Lordship, the second issue over here which we will be dealing with is whether the use of trademark by VCW is proper as per scope of the Trademarks Act under section 134. The Trademarks Act of 1999 includes the use of domain name as part of the right held by a registered trademark holder. Section 2, subsection 1Z of the Trademark Act also states that service basically means of any description which is made available to the potential users and includes the provision of service in connection with business of any industrial or commercial matters. In this case specifically, VCW and B, which runs multiple websites all over the world with different domain names such as www.vcw.eu and www.vcw.gb, we interact with our consumers on the front end as well as we run our back end operations. On the front end, we communicate to our consumers any new products, any new development of our business and any expansion. As it is mentioned in the Moot code preposition, VCW and B entered India in 2019 under the Invest in India scheme. We got certain concessions as well. When we entered into India, there was a mandated business practice by the food aggregator delivery based apps which said that owning a domain name is necessary as a good business practice. VCW and B, being a registered trademark holder in over 35 countries, which including India, should be classified as a well-known trademark. The Indian legislation provides protection of a well-known trademark as India is a part of the Madrid Agreement, and the classification given to determine whether a trademark is a well-known trademark or not is given under section 11 subsection 6. There are a few requirements which I would like to read out to further my point that VCW and B is a well-known trademark. They are that the recognition of the trademark among the relevant public, including in India through promotion.
Section 11.
Yes, Your Lordship. Section 11, subsection 6. It provides a few certain conditions on whether intellectual property is a well-known trademark or not. If Your Lordship would allow, I would like to read out the exact wordings from the BEAR Act.
Yes.
The registrar shall, while determining whether a trademark is a well-known trademark, take into account any fact which he considers relevant for determining a trademark as a well-known trademark, including the knowledge or recognition of that trademark in the relevant section of the public, including knowledge in India obtained as a result of promotion of the trademark, duration, extent and geographical area of any use of that trademark, duration, extent and geographical area of any promotion of the trademark, including advertising or publicity and presentation at fairs or exhibition of the goods or services to which the trademark applies. The duration and geographical area of any registration of or any application for registration of that trademark under this Act to the extent they reflect the use or recognition of the trademark. And lastly, the record of successful enforcement of the right in that trademark, in particular, the extent to which the trademark has been recognized as a well-known trademark by any court or registrar under that record. Your Lordship, I would like to bring your attention to an observation made by the Delhi High Court in the case of, pardon my pronunciation for the German word, Daimler Benz Acti Gesellschaft and others versus Eagle Flask Industries Limited. The observations in its interpretation basically said that Mercedes-Benz has been a very well-known trademark throughout the world. Even though if it was registered in India, in 1951, and there was Eagle Flask Industries, which was using Mercedes-Benz as their own trademark on flask and other cutlery products. It was still a violation of the trademark name held by Mercedes-Benz, because to be more clear about it is that Mercedes-Benz, along with its symbol, a three-pointed star in a circle ring, have always been linked with the car, and that such a connection could hardly be ignored. Even if it was registered in India in 1951, the fame of the mark was worldwide as being one of the most well-known marks in the world, and such a mark is not up for grabs, not available to any person to apply upon anything or any goods. Your Lordship, we would also like to then further strengthen our point that VCW&B having global recognition, we claimed www.vcw.in for global standards. As a case mentioned by the counsel of the petitioner, which was Rajat Agarwal versus Spartan Online, there were two conditions, there were dual conditions. One was branding procedure and consumer navigation. Being an internationally acclaimed trademark, we completely prioritize a uniform set of standards of our branding, marketing, advertising, and even production of our goods and services to the public. And the second, consumer navigation, as already pointed out, we use our website on a much wider scope than used by the petitioner. That is why when we asked for global uniformity, that was our main contention, so that there is uniformity across all platforms of our website, as well as global standards are matched. Hence, the unauthorized use of the domain name, that is www.vcw.in by Vakil Chaiwala, constitutes a clear infringement of VCW&B's trademark rights, which are recognized under the Trademarks Act 1999. And the counsel of the petitioner had also claimed that we were claiming misrepresentation on their part, which we have never ever claimed in front of any tribunal or any court or even during the arbitration proceedings. All we requested was the delisting of their domain name and to be handed over to us for our global uniformity of branding procedure, because the cost incurred on our behalf to rebrand our complete structure would be a very large inconvenience. If your lordships are satisfied, can I move on to the third issue?
Yes.
The third issue is that the arguments before High Court in writ under Article 226 of the Constitution of India and the commercial appeal under Section 13 of the Commercial Court Act of 2015. Your Lordship, the arguments presented by the petitioner under the writ are a ploy to delay justice and obstruct this resolution of this matter. The INDRP and its rules of procedure were adopted by NICSI. NICSI being established in 2003 by the government under Section 8 of the Companies Act. Its main function was to manage the .in registry and to resolve the disputes relating to the domain names. And the council would also like to bring your attention to the case of Harbanslal Sania versus Indian Oil Corporation Limited. I would not be reading the exact extracts to save the time of the court, but I would like to put forth the point which they were heading towards, which was that the court had emphasized that when alternate forums are already available, that should deter courts from exercising writ jurisdiction unless there is a breach of natural justice or fundamental rights. In this case, there was however, no such breach of the principles of natural justice, either the fundamental rights, as both parties were given an equal opportunity to present their case before the learned arbitrator by filing a 5,000 word written submission with an annexure along with attaching of annexures, but such complaint could not exceed 100 pages. These limitations was applicable to both the parties. There was no bias, there was no preferential treatment given to either party. And moving on to fundamental rights, there was no violation of it, as we have already given them a right to be heard. We were also being given the right to be heard. Hence the impartiality of the arbitrator which was being challenged and the procedure with which they were elected is on a very shaky basis which was put forth by the counsel of the petitioner. Hence, we would like to humbly ask that this makes this particular writ not maintainable before this Honorable High Court. I would like to also further on to the second part of this issue, which is the commercial appeal under Section 13 of the Commercial Courts Act. Under Section 13 of the Commercial Courts Act, it provides a clear procedure of hierarchy of court system to apply when a pecuniary subject matter is available for dispute. According to the amendment, the valuation of a subject matter was reduced from 1 crore to 3 lakh rupees. In Maharashtra specifically, according to the Gazette notification by the Maharashtra state government, it is that any suit valuation of 50 lakhs can be tried in a commercial court. Over here, the petitioner has directly bypassed the procedure and the hierarchy and immediately gone before the Commercial Appellate Division of the Honorable High Court at the Nagpur bench. Whereas we claim that according to following proper procedures, they should have gone directly to the Nagpur court, to the commercial court at the Nagpur bench. That is how proper judicial oversight could have been done, and if an order was passed which aggrieved either party, there is a proper procedure to go towards the Commercial Appellate Division. And relating to the pecuniary subject matter, it is clearly mandated that only pecuniary subject matters of above 1 crore can be directly tried into the High Court. The council would seek that if there is any clarification required on your lordship's part, the council seeks permission to move on to the prayer. Wherefore, in the light of issues raised, arguments advanced and authorities cited, it is most humbly prayed before this honorable court that it may on the basis of the prior and foregoing written submission be pleased to adjudge and declare that to kindly uphold the impugned interim order passed by the arbitrator according to INDRP and its rules of procedure, to kindly dismiss the litigation onslaught brought by the petitioner, and to kindly acknowledge the respondent's demands for damages of 2 crore rupees only for litigation cost and decide on its validity as per the law and facts of the case, and or to pass any other order it may deem fit in the interest of justice, equity and good conscience, all of which is most humbly and respectfully submitted.
Your Lordship, there are few things to be taken into consideration. First, when it came with regards to statutory authority, the learned respondent stated that the statutory authority comes from clause 8 of the Articles of Association. Articles of Association, for the clarification, is made by the company itself. So today, if I begin a company wherein I state that I from today will have the power of a stock broker exchange, so will I be having that power from tomorrow? No, that's not possible. So, and more importantly, with regards to this, that Articles of Association states the function of a company. It doesn't give it a statutory power. Statutory power only comes with a statutory legislation made by the legislative. Even presidential orders, constitutional orders, governor orders are taken into consideration as administrative orders. Even those orders are not taken into consideration as statutory orders. Statutory legislation can only have the power to begin statutory arbitration. Articles of Association cannot give anyone this power. Now, with regards to the other thing, Learned talked about the case of Tata Motors and challenged our case on the basis of the same. Your Lordship, in that case, two same domain were challenged on the coexistence. In the present case, the same thing is happening. Probably facts are always different of each and every case. The law has to be taken into consideration. The law is same. Now out over here, the mooter number 2 pointed out, or the mooter number 1 pointed out that one of our case is not similar to the case just because one of the class 42 is different. Now how? The learned respondents in the other council stated the Mercedes-Benz case. Mercedes-Benz case trademark is different. The class of the trademark doesn't come under 42. then how they are quoting this, quoting that case? If we cannot quote a case which is not of the same class, how can they quote it? They are using the precedents in a manner that favors them. This is one of the things to be taken into consideration. Now moving forward, with regards to the Madrid agreement that was stated by the learned Moot. Madrid agreement comes under Article 51 of the Constitution of India. It only states that only if there is a need to do this, there is a need of, if the present legislation of this country are not enough, then we can refer to international guidelines, international conventions, international agreements. Out over here, if we refer to the section 34 of the Trademarks Act, it clearly states that prior use is important and it has to be maintained. If we already have a legislation which speaks about the section 34, which speaks about prior use, then how can a Madrid agreement between different countries and all can sustain out over here? The law of the nation sustains. Now with regards to the other thing, post-grant opposition. Now the learned Moot stated that they have nowhere, in no jurisdiction have challenged our trademark. If the lordships refer to the facts of the case, learned respondent mates have, though this case is not in the powers of the present bench, but they have, what they stated, that they have nowhere claimed our trademark. Post-grant opposition was filed by the learned respondents in the trademark registries. Then if they didn't, if they are stating that they have nowhere claimed our trademark, why did they file post-grant opposition in front of the registrars, the trademark registry? They shouldn't have filed that. Now with regards to the other thing, which is one of the most important thing, the learned Moot stated that there was a writ jurisdiction which is not maintainable, because we had to approach to alternate forum. As much as I know the law sustains that writ can only be filed in High Court and Supreme Court, and only I can challenge a policy framework, the constitutionality of policy framework with certain severable principles only in front of High Court and the Supreme Court. The first place I can approach to is the High Court. I have done that. So I have not surpassed any constitutional limits. Now with regards to the commercial appeal, they stated that the commercial appeal should not be maintainable. Your Lordship, pecuniary jurisdiction of our case was 1 crore, and more importantly, this was with regards to procedural law. Now, if the Lordships refer to the Moot proposition, it has to be noticed that the maintainability, which has been challenged by the learned respondents, the maintainability has already been decided by this honorable court. Now, again challenging the same would be just like deciding upon the competitiveness of a bench of a court. That was it. Much obliged.
Your Lordships, the Council would like to state that the petitioner has stated the instances of cyber squatting and bad faith. The respondent would like to state that these post-grant oppositions which the petitioner is talking about is filed under the trademark registry, which the Supreme Court has clearly stated are not to be entertained by this Honorable High Court, and also that the petitioner has also stated about the competition law, again, which is filed under the Competition Commission of India, again which the Supreme Court has stated that the Honorable High Court is not to entertain these conditions because these are to be separately tried by the Registry of Trademarks and the Competition Commission of India. Secondly, that the petitioner has stated that Article 51C of the Constitution also emphasizes the need for fairness in arbitration. The article is invalid here because 51C of the Constitution talks about the promotion of international peace and security, which is in no way relevant to the personal hearing in this case. Thirdly, that the petitioner has also stated a case of Rayons versus Union of India, but they have not given the correct citation also, and that the case is also not related to the personal hearing. Also, the petitioner forgot to mention the one important thing in the second issue, that they have not proved how domain is a part of the trade name. Because they have started that, that the trademark registration is there. Yes, that's absolutely correct. But how is the domain name www.vc.in is not even correct provably with also with the case laws. Also that, yes, your lordship, the petitioner has also stated that there is a unilateral appointment of the arbitrator by NIXI. Here, the council would like to state that there is not a unilateral appointment of NIXI as stated in the clause 5 of the INDRP, which clearly says that there is an empaneled list of arbitrators, and also that there is already alternative remedy available to the petitioner. Yes, in the INDRP rules of procedure, which is the clause 11D, your lordship, which clearly states that if the petitioner has a problem with the neutrality or the impartiality of the arbitrator, they can go to the NIXI or the IND registry, which the petitioner has failed to do so. Yes, your lordship. Much obliged, your lordship.
All the participants did wonderful job. All the participants did wonderful job. We must give them a round of applause. It is hardly matter the law in whose favor, particularly in moot competition. What is to be seen that how the council presented their case, how they have articulated, how they try to convince, and whether they have sufficient knowledge of law, irrespective of the matter in whose favor it will go. That to all, it is very difficult for both of us to choose one of you, one of the party. Both the teams did wonderful job, but we have to go by the calculation that we will be doing within short passage of time. And I congratulate both of you for participating very well. So far, just you can sit, please. Just so far as law on this trademark is concerned, we all know that before the statutory provisions there were action of passing off under the common law, and after the enactment of Trademark Act, earlier Act, now new Act, the infringement provisions has been incorporated. If the trademark is registered, then he will be exclusive user of that register. Only exception 34 is there, that the plaintiff has to show that he is in prior use. Then with the defendant who has got the trademark registered, that is the settled law. Then if otherwise, you can go for passing up action which was under common law. But so far as infringement is concerned, the plaintiff has to prove that he is prior user of the trademark which has been got registered by the defendant. So, and then if there are, so far as the other statutory provisions are concerned, that both the parties have done very well. So once again I will thank you. I will thanks the organization to who invited us for this wonderful event. Thank you.
My esteemed colleague, Brother Justice Chandwani, Principal of the college, other members of the organizing committee, Mr. Brahme, who is always after us to bring us here. He not only as an advocate has a persuasive skills as well in the court, as well as not only in the court but also in the chamber when he comes to invite us for such a program. And I must tell you that we are proud to be a part of this function. So well organized. The organizers deserve a compliment. The young team, and I must tell you that Shirin is one of them. He is my favorite intern. So you see, one day in her life she will be a successful judge. Mark my words today. Please sit. As said by my brother, winning and losing is a part of a life, so don't worry. But I must tell you frankly, you both teams have a bright future. They deserve a round applause, please. I must tell you, if there had been no time constraint, I would have insisted them to argue for one more hour. And same thing about you as well. You people are too good. You have put in a sincere hard work. You understood the facts of the case. So nowadays we tell the advocates that be a master of the facts. Unless and until you are master of the facts, it is very difficult to raise this structure and apply the law. You know, see here, once your foundation of a fact is solid, then applying the general principles of law and the common sense principle of, there's a pigeonhole theory. You know, you must have seen, so to find out a hole and fix the pigeon. It is very, very easy then, which we could experience when you answered our queries or the questions. Our attempt was, it was not to really know from you what you have understood. It was just to test your mettle, whether you could get distracted when somebody asks you a question in the midst of your argument. So you have done a wonderful job. We are very happy, and I must tell you, Mr. Brahme and other senior advocates, that after 10 years, you will see totally a new transformation on the bench as well as in the bar. This is a good sign for democracy and particularly for independence of a judiciary. Your future of a judiciary will be in your hands, and the way you people are performing, we believe and we are satisfied that the future of a judiciary would be in a safe hands. Now one thing which is most important, some of you may go to litigation, some of you may go to non-litigation academics, some of you like Sirin may choose the judicial service as a career. Wherever you go, have a discipline. Please take care of your health. Nowadays, the priority is to the mobile WhatsApp than to the health. So my request to all would be that if you want to sustain and survive long, please take care of your health. I have been telling advocates and my brother judges, despite repeatedly, whether they follow me or not. You know, that brother and sister, out of 24 hours, please devote 30 minutes for your health. 30 minutes of exercise would be your greatest investment for that day. So 30 minutes multiplied by 30 days. So we are there, we are working, we will be working, you will be working, but at the end of the day, what matters or what would matter is the satisfaction. You may derive the satisfaction by your work. You can derive the satisfaction only you are physically fit. It is said that that the healthy body carries a healthy mind. So please take care. Now this is the proper age to have that discipline. As far as I am concerned, I have told your management that I get depressed in my life if I don't read a book and if I don't do exercise. And that is why I have been able to work to my satisfaction. I am enjoying. This is the penultimate month of my retirement, but even today I am enjoying. I am enjoying because I have been passionate about this profession, and the way you people are involved in today's work, it appears that you are not here because of some compulsion. You are here because you are passionate about this profession. It is not that you have chosen this field because you had no choice, but to come to this field. And I must tell you and share with you my experience. You have a today senior or today junior may become a senior after 10 years. You keep this in mind. Don't be after money. Money will follow you. But you have to lead a disciplined life. You have to be thoroughly prepared. You must be eager to learn something every day when you enter the court premises or office of your senior. So thank you very much. This is my second year to address you. Be careful while interacting with your colleagues, arguing against your colleagues. So why in a reply I could notice that the young man was a bit angry. He did not like the submissions. You may like, you may not like. You are not there to convince your opponent, you are there to convince the judge. And if you get angry, the judge may feel that a man is on slippery ground. So don't allow anybody to form that opinion about you. Thank you very much. And it is a privilege to be in the midst of young people. Mr. Brahme may agree with me that the people of our age say that don't say we are old, say at heart we are young, but when we come and mingle with the young people, we feel that we are also young. That this feeling, if carried positively, it is always good for your health and your mental build-up. Thank you very much, organizers, once again.
Thank you, sir. Your guidance is invaluable and will undoubtedly leave a lasting impact on all of us. Thank you to all the participants. Your dedication and hard work has been truly inspiring. You have shown us that the future of legal profession is in capable and passionate hands. Mooting is not just about the law. It's about presenting it with conviction, logic, and clarity. And your performances today were nothing short of remarkable. Each of you has shown the spirit of advocacy and the ability to think on your feet, which are the hallmarks of a successful lawyer. Thank you so much.
And he has taken a promise from Mr. Brahmi and your principal that before I leave Nagpur, after my retirement or I demit my office, I should come here and share my experiences about the Bamla's case with you. And on your behalf, I have promised them.
In the words of William Arthur Ward, feeling gratitude and not expressing it is like wrapping a present and not giving it. As this remarkable event comes to an end, we pause to reflect on the success of the day and efforts that made it possible. It is time to say thank you to everyone who made this day special. I would like to invite our student coordinator, Ms. Abhaya Bansod, to come to the stage to deliver the vote of thanks.
Thank you so much. Good afternoon, everyone. As we come to the conclusion of the 22nd Justa Causa Moot Court competition, my heart is brimming with joy and gratitude. This event has been nothing short of spectacular, and it is my privilege to stand before you today and express my heartfelt thanks to all those who made it a success. First and foremost, I extend my deepest gratitude to our esteemed judges for the final round, Honorable Justice Sanap Sir and Honorable Justice Chandwani Sir. Your presence here today has been truly inspiring, and we are so grateful for the time you took to share your invaluable insights. Deciding the winners of this competition could not have been an easy task, but your expertise and fairness have made this event even more special. I also want to take a moment to thank our guiding light, Mr. Ravi Shankar Moore sir, our esteemed principal, and those who supported us, Dr. Pravina Khobragade madam and Dr. Adhara Deshpande madam. Your leadership, dedication, and belief in us have been the driving force behind the success of this competition. I would also like to thank the judges who evaluated the preliminary round, the quarterfinal round, and the semi-final rounds. Their keen observation and thoughtful decisions have paved the way for this thrilling finale that has nothing but remarkable. A special thanks also goes out to the teacher coordinators, Ms. Vidya Naik madam, Ms. Gargi Chaube madam, and Ms. Pooja Bhandari madam. Your guidance, patience, and constant encouragement kept us on the right track, and we are so lucky to have you as our support. I would also like to thank my esteemed and incredible coordinators, Arpit, Anuj, Sejal, and Vedika, and all the other volunteers that have helped us. Lastly, to everyone who participated, attended this competition, a big thank you. Your passion, your energy, and enthusiasm has brought to this event a very unforgettable experience. This moot court competition is not just about winning and losing. It's about learning, growing, and celebrating the spirit of law. And all of us have embodied that perfectly. With all that, I conclude this vote of thanks with a heart full of gratitude and pride. Thank you to all. Let's carry this joyous momentum forward into our futures. Have a wonderful evening.